So this video addresses what do you do if an heir just flat out refuses to accept the money that they're entitled to inherit. I'm Paul Rabelais. I'm an estate planning attorney. I help people really all over South Louisiana arrange their legal affairs so things are simple when they die and make sure things go simple when they pass away. This doesn't happen much, but it happens from time to time. We handle a lot of probate succession legal work in our office. And occasionally someone just doesn't want to have any contact with the family. Let me just give you an example. Let's say mom died. Let's say she had 6 kids, and each child is entitled to 1/6 of mom's $600,000 estate. So every child's entitled to $100,000. But there's one child didn't go to the funeral, won't return phone calls, won't return texts, won't return emails, won't come to the door, won't return registered mail, just wants nothing to do with the family. And what do you do in order to, complete this court supervised proceeding? So what we're not going to talk about in this video is what is more common is when someone actually informally refuses and does all the paperwork to refuse, or the right tax word for it is they disclaim their inheritance, or in Louisiana we call it they formally renounce their inheritance. That's not that uncommon. Some people disclaim their inheritance because they want their inheritance to go to the people that it would go to upon the disclaimer. Maybe a child says, I'm going to disclaim it because I know that if I disclaim it, it's going to go on down to my children. I want to go ahead and let my children have it. Or sometimes there's some income or gift or estate tax benefits to formally disclaiming an inheritance, particularly if it's an IRA and lots of income tax consequences there. So we do see a lot of disclaimers. That's not what this video is about. This is for the one who just refuses to have any contact. So our Louisiana law has a procedure for that, and what it says is that after a hearing, a court can order the executor to deposit those funds in either a state or national bank, or in what's called the registry of the court to the credit of the person who's entitled to the funds. So there's a hearing, court orders that, the executor gets a receipt that the deposit has been made, and now the executor and the rest of the heirs can go through the procedures to finish everything up, get the executor discharged, and that money will just sit there. Now, there's a different procedure though. What we just talked about was if someone's entitled to inherit money. Let's say, in our example, mom said, I want son, and she named him, to get my diamond engagement ring. And again, no contact, doesn't want it, doesn't respond to anything. So if it's one of those what's called corporeal movables, kind of an item, a physical item, and someone's refusing to accept it and sign a receipt for it, then really an executor can petition the court, and a court will make and the executor can make the disposition that the court directs. So court's got some discretion on what to do there just to get things finished up. One other example that worth mentioning is, what we talked about up until now was it's in the probate estate. What if the assets are held in a trust and the person refuses to accept the trust distribution? We'll see that occasionally because many people these days, in an effort to avoid the court-supervised succession or probate proceeding, they'll put their assets in a trust, name perhaps a family member as the successor trustee to disperse it out of the trust when they pass away outside of the court proceeding. So I suspect if there is a trust beneficiary who won't communicate, refuses to accept the $100,000 or whatever it might be, I suppose the funds would just sit in a trust account for the benefit of that person who refuses to accept it. And it would just sit there, and perhaps financial institution fees would eat at that for many years. But that's the deal there. So kind of unfortunate when that happens. You would think that if someone is notified, hey, there's an account with your name on it and it's got $100,000 in it, all you got to do is go to the bank and get it, you'd think that they'd go ahead and do that, but everybody's different, families are different, and who are we to judge those emotional and relationship issues that sometimes surface after many, many years. So just wanted to let you know that there is a procedure. Sometimes families get stuck and they just don't know what to do, but there are procedures for these types of things that are a little uncommon. So this is just one of those examples of things that I didn't write about in my book, because my book covers the typical scenarios, and this is not a typical scenario, but just thought I'd share that with you in case you get caught in a situation like that. So hope that helps. Make sure you take care of your legal affairs, and you'll be doing your family and loved ones a big favor. I'm Paul Rabelais. Have a great day.